Great. Nice to meet you all. Thanks for taking time to be part of this presentation. So yeah, I'm going to share my screen and I have a PowerPoint that is really just the basics of estate planning. Obviously not diving into the weeds and too many topics because it's different for each person. And in this case, it's different depending on the state that you live in. But a lot of estate planning is the same general thought process and concepts, no matter what state you're in. I'm in Massachusetts, so I will mention a few Massachusetts tidbits, but I will also mention what areas are different depending on your state and what areas are the same, depending on what state you're in. So these are the topics we're going to discuss today. Basic documents that everybody should have. And then we'll discuss different types of trusts. We will discuss estate taxes, which really is very state dependent. And estate tax planning is very state dependent. Probate is pretty much the same across the board. We'll discuss that. We'll discuss the typical decisions that you should be thinking about when you're deciding to do your estate plan. Homestead, I'm just going to tell you about Massachusetts, but there's probably something equivalent. And then at the end, I'm going to mention important documents for adult children, which many people don't think about. So let's get started. And I'll go through some of the questions from the chat in a little while, but let's just go through some basics. So many times people hear the term estate planning and they think, well, I don't really have an estate. I don't really need estate planning. Estate planning has nothing to do with wealth. It's also not just for death. Any documents that deal with death or while you're alive, naming people to make, decisions is part of estate planning. It could just be doing a simple will. That's an estate plan. So basically there are two parts of estate planning. One is what happens at your death, who you want to name as guardian for your children, or if you're all going towards retirement, you probably don't have minor children, but and then managing for your affairs while you're alive, naming people to make your decision while you're alive. And that's very important. Some of those are the simpler documents, but I think in some ways more important because they're for while you're alive, making sure that somebody can take care of your needs and knows what you would want. Okay, so here are what I call the three basic documents that everybody should have: married, single, no matter what state you live in. You should have a will. If you do have minor children, this is very important because it's the only document where you name guardians for minor children. You also name what's called the personal representative, which is sometimes known as executor. And that's the person who basically handles things at your death. They hire the lawyer. If there's probate, which we will talk about soon, they sign off on that paperwork, but they kind of should be an organized person. It can be a child, it can be a sibling, it can be a bank or an attorney. I usually recommend family members as the first place to go for that. So the will is, if you don't do any kind of trust, the will is where you say where things pass at your death. The power of attorney and the healthcare proxy are very similar. They're while you're alive, but they're for two different types of decisions. The power of attorney is for dealing with and accessing financial real estate type assets, signing your name to things like taxes, like applications for nursing homes. So it's a very broad power. You're naming someone who can basically act as you. The name of the person you're naming is referenced in the document as something called attorney in fact. It has nothing to do with being an attorney. It doesn't have to be an attorney. It usually shouldn't be an attorney. And it's just somebody who acts as you while you're alive. There are two types of powers of attorney. The more common type is immediate, which particularly with spouses, you would name each other and you would make it immediate. It means it's effective upon signing. So even if you're not incapacitated, your named person can go to the bank for you, can sign your name for things for you, can refinance the house if you're away out of town and there's a closing for a refinancing, they can sign your name. If you're nervous about it, there's a type called springing because it springs into effect only upon your incapacity. So the positive is that it's a little more protective in that the person can't act unless you're unable to act. The negative is that there's a little bit of a delay when you need to use it because you have to wait for a doctor to evaluate you and write some sort of a letter or a statement that says you're unable to manage your own affairs. So depending on who you're naming and how comfortable you are, you might make it the immediate type or the springing type. I've actually done powers of attorney where the first person, let's just say the spouse, is immediate, but the alternate, a sibling, let's say, might be springing. So if the spouse is not alive, the next person only can act if you're proven to not be able to act on your own. So, and then similar to that is the healthcare proxy. That's what it's called in Massachusetts, but in many other states, it's called power of attorney for healthcare. Very similar, only while you're alive, ceases at death, just like the power of attorney. This is just for medical decisions. And in most states, it's not effective unless you're unable to make or communicate your medical decisions. It usually includes something called HIPAA, either in it or as a separate document, which is, so the healthcare proxy is saying you could make my medical decisions. The HIPAA document says you can access my information. You can get medical records, test results, things like that. And then some people want to include something called a living will. Do I have that on the next page? Let me see. Yes. So some healthcare proxies, either separately or included in the document, include something called a living will. It's actually not legally binding in Massachusetts, but is in most other states. And it's your statement that you don't want to be kept alive by machines if you are permanently brain dead. This is different from a DNR. A DNR you don't put in the healthcare proxy. That you do with your doctor, and you only do it if you're terminally ill, because that says you don't want your heart started if you have a heart attack. Living will is more, if I'm brain dead, I don't want to be kept on machines indefinitely. And then some people include organ donation, but I always recommend that if you put it in your healthcare proxy, you also sign up with an organization. Like in Massachusetts, there's something called New England Organ Bank. And then you get a sticker for your driver's license, because it could be that something happens to you and the healthcare proxy never comes into play. So it's important that if you do want to be an organ donor, you set it up outside of your healthcare proxy as well. Any questions so far? Okay, great. We'll keep moving on. Okay, so here, in addition to so everybody should have the three basics: a will, a power of attorney, and a healthcare proxy. And again, to summarize, the healthcare proxy can include in it or as separate documents a living will, which is about machinery, organ donation, and the HIPAA, which allows people to access your information. Those three documents everybody should have. Old, young, married, single. Then there are different types of trusts that you can add to the mix depending on your situation. So a single revocable trust, which would be for an individual or a couple, the two main reasons for doing this is if you have any beneficiaries that are either young or not good at handling money, and you want to say that at your death, their share doesn't go to them immediately. It gets held in trust until a certain date or a certain age. And before those ages, the money would be accessible to them, but they wouldn't be able to access it and misuse it on their own. You would have a trustee that could use the money for them. So that's one main reason for a single trust. The other reason for a single trust is to avoid the probate process at death, which we'll get into in a little bit, primarily for real estate, since most assets other than real estate, which are pretty much financial assets, already avoid probate by naming beneficiaries. So we'll get more into that in a few minutes. Depending on your state and whether it has an estate tax, which many states do, two trusts would allow you to double your state's estate tax amount. So Massachusetts, the estate tax level just moved up from $1 million to $2 million. It's actually one of the worst in the country. Most states are higher or have come up to federal, which is 12 million. But in Massachusetts, a married couple could set up two trusts that would allow them to double that 2 million so that they'd save their kids or their ultimate beneficiaries money at the second person's death. And the third type of trust that you might want to consider is an irrevocable trust. The main type is an insurance trust. There are other types of irrevocable trusts, which I'll just mention. But if you have a substantial amount of insurance, people don't realize that insurance is not taxable to the beneficiary as income. But when you add up your estate at your death to see whether there's an estate tax, again, state dependent, let's just say your state has a $5 million threshold, and you have assets other than insurance that add up to 4 million, but you have a $2 million life insurance policy, your taxable estate would be 6 million. An irrevocable insurance trust allows you to get the insurance out of estate taxes. So I won't go into detail because it really only applies to some, but it's just good to know about it. And depending on who you end up working with, you would discuss it if it were necessary as part of your plan. Okay, so here's information about estate taxes. And again, this is very state specific. Federal, let me just admit this person. Federally, the threshold this year is high. It's been high for a number of years, 13.61 million, automatically doubles. There's something written into the law called portability, which automatically allows married couples to double it to 27 million. So if you have less than 13 million as a single person or 27 million as a couple, you don't have to worry about the federal estate tax at either person's death. If you are over 27 million, the estate tax is 40%, but only on the excess over that total. It is scheduled to decrease all the way down to 5 million in 2026, which when they first wrote this seemed like it was so far away, and now it's in a year and a half. It's probably not going to happen, but there's no predicting. The estate tax has never gone down in the history of the estate tax, but it may. No one can predict. If it does, there'll be more estate taxes to be paid because more of you will be over that level. So the state estate tax is very variable. Some states don't have an estate tax, like California or Florida. New York has an estate tax, but it's up to, I think, about 6 million. So it really depends, and you could just Google your state and find out what it is. But whoever you work with in your state would give you the information and determine whether it's something you need to include in your planning. But it's something to be aware of. So here's where we already talked about these things, but if you're married and you live in a state that has an estate tax, two trusts will allow you to double the state estate tax and save money for the next generation or whoever your heirs are, whoever you're leaving things to. The negative is that after one of you dies, let's just say the estate tax in your state, like Massachusetts, is 2 million. So if people set it up in Massachusetts, when the first spouse dies, let's say it's the husband, the wife gets to commingle everything with her own assets, except for 2 million stays in his trust. And the spouse gets the benefit of that trust, but shouldn't use it unless she uses up her own assets, because whatever is unused of that 2 million is not taxed at the wife's death. So that's how you're saving the estate taxes, because you're preserving both people's 2 million. And again, the other thing that saves money is you can set up irrevocable insurance trusts if you have a substantial amount of insurance that puts you enough over the level of your estate that it's worth thinking about. Okay, here's probate. Now, probate is completely separate from estate taxes, much more state, not state specific, much more the same among states. So and often people think estate taxes and probate are the same thing. They're totally different. Estate taxes have nothing to do with the way you own assets. It only has to do with the value that adds up at your death and whether it's over the level of your state's estate tax laws. Probate has nothing to do with the value. You could have $1 million or 30 million, and probate applies to certain assets. Probate is the mechanism for getting the title of assets to the next person in line. So the only assets that go through the probate process and that go through the will are assets that are in your name alone. No joint owner, no named beneficiary, and not titled in a trust. So usually these days, it's only real estate, because retirement plans and life insurance, you name beneficiaries. And even taxable accounts, they used to not really allow it, but now they all allow either a beneficiary or a pay on death, which means you get to keep it in your own name, but then it passes at your death without going through the will and avoiding this probate process. Now, the probate process, people like to avoid it because it's time consuming, it's paperwork, and it can be expensive. It's the same process in all states, but each state has its own timetable. Massachusetts, it's a year. I think Florida is either 6 or 9 months. New York is 9 months. Most of the work is at the beginning, at the end, and things like real estate can be sold during probate. But if you can avoid it, it's a nice thing to avoid. By the way, this will be shareable. This PowerPoint will be shareable with whoever wants it at the end of the presentation. Okay, so how to avoid probate. So for real estate or anything else that doesn't have a beneficiary, you can retitle it into a trust. We talked about that single trust. If you don't have an estate tax situation and you just want to avoid probate, you could set up a trust. You retitle your real estate into the trust by recording a deed and some other things at the Registry of Deeds. You still have total control. It's just a paper transfer, and then the real estate passes immediately at death and doesn't have to go through that process. You also might want to do that for real estate or tangible personal property in another state from where you live. You live in Massachusetts, you have a summer house or a winter house in Florida. You want to avoid what's called ancillary probate, which is a secondary probate in another state where you own real estate. And again, as I mentioned, probate and estate taxes are completely different. So that's estate taxes and that's probate. So here are the typical things that you want to decide upon. So I look at it as you decide the big picture first. I want the 3 basic documents. Do I want a trust for probate avoidance? Do I want a trust for later ages of distribution? Do I need 2 trusts for estate tax savings? Once you decide the big picture, then you decide all the provisions that go into the documents. So the first is, who are you going to name as executor in your will? And again, you're naming them in the will, but if there's never any probate, they never actually get the job. Guardian for minor children, that would be raising them until they're 18. If you want someone else to be in charge of the money, you would set up a trust. And you can name 2 people as a guardian in a will, but it's always very important. Often people name a sibling and a sibling spouse, but it's very important to think, do I really want to name both? If my sister's not alive, do I really want to name her husband, or would I move on to the next couple? So that's an important thing to think about. Then you want to think about who you want to name in your healthcare proxy. It's often life or death situation, but it could be as simple as, having your wisdom teeth out and you're under anesthesia and they have to decide whether to take another tooth. So it's anytime you can't make or communicate. So you want to decide who you want to name for that. The power, and it's going to be someone that you're going to want to let them know what your wishes are for certain circumstances. Power of attorney is, again, while you're alive, naming somebody to be able to act for you and sign your name. And again, you have the choice of the immediate or the springing. And this is a very broad power, so you should really name someone you trust a lot. There is a relationship called principal agent where you could sue them if they misuse the power, but best to name somebody that you really feel comfortable with.
You did say it can be your child, right?
It can be your child, but let's just say you're having a trust and you're saying your children aren't getting everything until age 35. Then you don't want to name that child as power of attorney, because if you don't feel comfortable with them getting the money right away at your death, then you certainly don't feel comfortable having them in charge of your money while you're alive. But you can name a child, yes. Then if you're setting up a trust, you need to name trustees for after your death. These would be in charge of distributing the assets at your death and working with other professionals to close out the trust, or to have it continue if it's continuing until later ages or later times for certain people. And of course, the most important thing you have to decide is who your beneficiaries are going to be, whether it's a will or a trust or direct beneficiaries of assets. Who you want to leave things to, whether it's individuals or charities, whether it's specific amounts to certain people and then percentages to other people. Tony, yes, you have a question?
Going back to the trustee, is there a difference between the trustee and the executor?
Yes.
Do you have do you have both of the?
Yes. So you would, if you're setting up a trust, you would have both an executor of the will and a trustee of the trust. It may be that you name the same person because it's the same qualities that you're looking for. So the executor of the will would only be handling probate if there's probate. The trustee of the trust would be handling making distributions out of the trust either immediately or at later ages if that's what you've provided in your trust. So the trustee is a bigger job. Does that make sense?
Yeah, thank you.
Okay, great. So getting back to beneficiaries, you want to decide who you're leaving things to, whether it's percentages or specific amounts. If you are leaving things to beneficiaries that are young or have issues, deciding whether you want them to get it immediately or at later ages. Also very important to decide if a beneficiary dies before you, how do you want that share to go? Should it go to that person's children or should it go to the other people you've named? And then it's also good to just kind of have a final distribution if none of the people you've named survive you. And for that, it could be your next of kin, or it could be specific individuals, charities, or a mixture of the two. And that obviously is going to be very different for each of you and what you want to think about once you know what document you're setting up.
I have a 20-year-old power of attorney. I don't believe it mentions immediate or springing. Will it default to immediate?
It probably says something at the beginning. It may not say immediate, but if it says, I hereby appoint blank as my attorney in fact, and it doesn't say it's springing, it's going to be immediate.
Okay.
Also,
and
20.
The
Also,
follow-up question
your follow-up question that I have an answer to without your asking it is 20-year-old power of attorney should be updated, because powers of attorney, it's not written into the law and you could fight it, but many banks and other financial institutions will give you a hard time if a power of attorney is old, sometimes more than 6 or 7 years. So if it's that old, you probably should do it again.
Thank you.
Was that the question?
Yes. Well, it was about revising
documents,
old documents. Yes.
Yes. Yeah. Okay, let me get to the next page and then we can go over some other questions that I see there. So this next is this, I'm going to do quickly because it's just Massachusetts. Massachusetts and other states have something called a homestead, but it's different meaning in different states. So you'd have to just find out from your own state. But in Massachusetts, there's something called a homestead, which gives you up to 500,000 if you're over 62 and you're married, up to $1 million of creditor protection against your home. So if somebody sues you and puts a lien on your home, they can't touch the first 500 people, oh my God, $500,000. It's now allowed for putting it in a trust as well. If you don't put it on record, you automatically get 125,000 of protection. So if your house is worth less than that, you don't need to record one. So we'll skip that because a lot of people are in different states. This next subject is very important because people don't realize it. If you have children who are over 18 and not in their own families yet, they should each have a power of attorney and a healthcare proxy, naming you or whoever they choose to make their medical and financial decisions. Because once they turn 18, you no longer legally have any rights to make their decisions, sign their names, get information, or anything. So it's really important that anyone over 18 have at least those two documents. Okay, let me go back and look at, that's the general presentation. Let me just go back and look at some of the, there were some questions I noticed from before that weren't answered. Okay, so I have documents in Mass, but I'm moving to Virginia. Should they be reviewed? Yes. If you know you're moving soon and you're about to do your estate plan, I always recommend having it done by an attorney in the new state. But if you already have them in place and you're moving, they will be legally recognized in the new state. So if you don't get them reviewed, they are still good and valid. But every state has their own laws. You might have set something up in Massachusetts for estate taxes that's complicated that you no longer need if you move to a state that doesn't have an estate tax. So I always recommend seeing someone, having it reviewed, and more times than not having them updated. Let's see, I'm going backwards. How important it is to have a trust for a married couple. Hopefully that question was answered about estate taxes and avoiding probate. Need impetus. Okay, I'm giving you the impetus, and you're in Massachusetts. Call me. Okay. Advice in finding an estate attorney. Okay, well, if you're in Massachusetts, feel free to call me. I offer a free phone call and a free detailed email with an overview of what you should think about. If you don't know an estate planning attorney, I'm on a listserv where people know people in other states, so feel free to reach out for me, and I'm happy to post on the listserv. Otherwise, one of the best ways is word of mouth and asking people you know. If you're new to an area and you don't know people, there's usually, like in Massachusetts, the Boston Bar Association has a lawyer referral service. So usually there's some sort of a bar association lawyer referral service that you could call. There's also a website called AVVO, AVVO, that you could look up attorneys and their reviews. So that's a good way to find somebody.